Americans support. I know you're disappointed, Mr. Cox.
I'm not disappointed. I'm outraged.
But that's what the Constitution says.
Well, can I add one more thing that's not quite exactly addressing what you asked? I do think there's a role for a co-equal branch of government, Congress, to make its own determination regarding how it wants its laws enforced. And I would urge this Congress to reconsider Calais in that light.
What started as a legal debate over redistricting quickly turned into a revealing confrontation over race and the Constitution. Senator John Kennedy repeatedly challenged attorneys on whether race should ever influence government decisions, and the tension escalated fast.
Kennedy. Thank you, Mr. Chairman. Mr. Grime, am I saying your name right?
You are, Senator.
You argued the Calais case?
I did.
Okay. I'm going to tell you my understanding of the case. And then, Mr. Cox, I'm going to ask you to tell me if Mr. Grime got it right. And Mr. Chamberlain, you can chime in if you would like. Are you familiar, Mr. Grime, with the Students for Fair Admissions case?
I am.
Okay, that's the case recently where the Supreme Court said you can't use race in college admissions. Now, here's what I heard the Supreme Court say in that case. I heard the Supreme Court say, look, colleges, we're not going to get into the admissions business. That's your business. We're just telling you you can't use race as a factor to admit anybody. Is that your understanding of the case?
Basically, yes. And they did a whole 14th Amendment.
Don't try to muddy the water to make it look deep, guys. I know you're all smart. I'm just trying to get to the bottom line. Am I wrong or right?
You're right.
Okay. Now, the way I read Calais is the Supreme Court is saying, look, first of all, these are political questions. And we're not going to tell the states how to draw congressional districts. We don't want to be in that business. That's a political question. We're just saying you can't use race as a factor. Is that what they did in Calais, or am I misunderstanding?
That's basically it. You can use it to remedy, past discrimination that you've proven. But that wasn't the case in the Calais case. The other side didn't prove it.
Well, but once again, you're muddying that water, man. Did the court, or did it not, say that you can't use race to draw a congressional district?
In most cases, you can't unless the state, the person defending the map, shows that they had to use it because there was a showing of immediately past intentional discrimination that they had to use race to unwind.
Okay.
Yeah.
Tell me whether he got it right, Mr. Cox.
Senator, quite frankly, the defense of the Calais case is such a tortured exercise. It's
Mr.
difficult.
Cox, I don't want to hear.
So I'm going to tell you what SFFA, how SFFA applies to Calais.
Did he get it right, or
he did not get it right? Okay. So under application to discuss Calais, you have to really discuss what happened in the case that created the district that was challenged in Calais. That was Robinson.
Right.
The court required the state of Louisiana to redraw its plans pursuant to its findings of a Section 2 violation.
Look, I don't
That's what justified the creation of the plan.
I don't want to have a fight. Can you just tell me, and you're smart, and I don't want to make this more complicated than it is. Tell me what he got right or wrong.
I'm telling you, what he got wrong was ignoring...
No, you're speaking like a lawyer, okay? And I'm tired of... I've listened to you gentlemen, okay? Let's just get down to it. Mr. Chamberlain, tell me what Mr. Grime got right or wrong.
You got it all right. You think I'm really going to tell the guy who argued and won Calais that he didn't understand what he was arguing?
Okay.
Sorry, I'm totally respectful. Obviously, I think he's got a good handle on it.
I understand that, Mr. Cox. I don't mean to be rude, the importance of precedent and all that. But didn't the Supreme Court say, except in very narrow circumstances, you just can't use race to help a person, and you can't use race to harm a person? And that includes in drawing congressional districts.
In answering that question, I'm going to tell you that the Robinson court, which gave rise to the district that was challenged in Calais, said that there was a violation of the Voting Rights Act, that it was required to draw a district or draw a redistricting plan that satisfied the Voting Rights Act, that allowed African Americans to elect candidates of choice.
You don't want to answer my question, do you, Mr. Cox?
I'm answering your question.
No, you're not.
Maybe an answer that you don't like and my colleagues don't.
No, you're not.
But I'm answering your question.
You're giving us another lecture, and this is not a common law class. Tell me in simple terms, is that not what the court said?
The court said a lot of things that were inaccurate. So the court said you can't use race at all in drawing plans. We disagree with that. But what the court really did was say that you can prove race you can prove there's intentional discrimination, which is in violation of this Congress's intent. It also sprinkled partisanship as a defense for any challenge to any challenge under Section 2.
All right, well, I'm about out of time. I can see no disrespect, Mr. Cox, but you're not answering any of my questions. And I know you're disappointed in the decision. But let me put it another way. Do you think race should be used to help a person?
I don't understand that question. Race should be
Sure you
used
do.
to help a person?
You think race should be used to help a person?
I believe that if there is a racial violation of the law, that race discrimination, I believe a remedy that's race conscious can be required, yes.
Do you think race should be used to harm a person?
I don't really understand what that question
No, I didn't
means.
think you would. Mr. Chamberlain, do you think it's fair in America to use race to help a person at the expense of other races?
No.
Do you think it's fair in America to use race to hurt another person?
No.
How about you, Mr. Graham?
Absolutely not. Race should not be used to help or hurt an individual.
And no disrespect to Mr. Cox. He's very bright. I can see that. And I've been where you've been. You know, when you get in front of a court of appeal and you're losing, you want to kind of obfuscate. I get it. But that to me is what the court's saying here in all these cases. We're not going to try to run your business. Not in college admissions, not in drawn districts. But you can't use race. Period. End of discussion. And I think that's what the Constitution says and what most Americans support. I know you're disappointed, Mr. Cox.
I'm not disappointed. I'm outraged.
But that's what the Constitution says.
Well, can I add one more thing that's
Sure.
not quite exactly addressing what you asked? I do think there's a role for a co-equal branch of government, Congress, to make its own determination regarding how it wants its laws enforced. And I would urge this Congress to reconsider Calais in that light.
Yeah, but you and I are both aware that the United States Supreme Court has full authority to pass on the constitutionality of a statute. Come on, you know that. I'm sorry, Mr. Chairman.
If Mobile versus Bolden is any example of what can and can't happen, this Congress can take a look at Calais and say, actually, you got it wrong. And you actually didn't interpret what we intended in 1982 correctly.
The problem with your argument is I don't think race should be used to help a person because of his race. And I don't think race should be used to harm a person because of his or her race. And I think that's what most Americans believe. And if you believe the opposite, and you clearly do, this is America. You can believe what you want. But the Supreme Court is deciding these cases.
I hear you.
Saying race is off the table.
I hear you. And I believe as a civil rights lawyer that if you find a violation based on race, you need to craft a remedy that addresses that.
Sure.
Senator Whitehouse.
I'm sorry.
This hearing rapidly evolved from a technical legal discussion into a larger national debate about race, fairness, and constitutional principles in America. Senator John Kennedy sharply questioned legal experts over recent Supreme Court rulings involving race-conscious policies and racial gerrymandering. His approach throughout the hearing was direct and intentionally simple. He repeatedly argued that government should not use race to either help or harm individuals when making decisions about representation, admissions, or political boundaries. That framing immediately created tension as legal experts attempted to explain the more complicated constitutional and Voting Rights Act issues surrounding the cases being discussed. Much of the confrontation centered around the relationship between recent Supreme Court decisions and the future of race-conscious districting. Kennedy referenced the Students for Fair Admissions case involving college admissions and argued that the court has increasingly moved toward limiting the role of race in public policy decisions. According to Kennedy, the same principle should apply to congressional district maps. He repeatedly suggested that the court's broader message is clear. Government should avoid using race as a determining factor except under extremely narrow legal circumstances. The attorneys responding to him, however, argued that the law still allows certain race-conscious remedies when addressing proven discrimination or enforcing voting rights protections. The hearing became especially tense when Kennedy appeared frustrated by what he viewed as overly technical legal explanations. Several times he interrupted witnesses and accused them of avoiding straightforward answers. His sharpest exchange came when he asked a series of direct moral questions. Should race be used to help a person? And should race be used to hurt a person? Those questions transformed the hearing from a legal argument into a much broader philosophical debate about equality and fairness in American society. While one witness defended limited race-conscious remedies in cases involving discrimination, Kennedy repeatedly pushed the argument that race itself should be off the table in government decision-making. The confrontation exposed a major divide that continues to shape American politics and constitutional law. Supporters of race-conscious legal remedies argue that historical discrimination and unequal political representation sometimes require targeted government action to ensure fairness and compliance with civil rights laws. Critics argue that using race in any official government process risks undermining equal treatment under the Constitution and creating new forms of discrimination. Kennedy clearly positioned himself on the side of a colorblind interpretation of constitutional law, emphasizing that many Americans believe fairness means treating people equally regardless of race. By the end of the hearing, the discussion had moved far beyond district maps or court precedent. It became a symbolic clash over competing visions of equality in America. Kennedy argued that constitutional protections increasingly demand race-neutral government policies, while civil rights advocates defended race-conscious remedies as necessary tools for addressing discrimination and protecting voting rights. The emotional intensity of the exchange reflected just how divided the country remains on issues involving race, constitutional interpretation, and the role government should play in balancing equality, representation, and historical injustice in modern American politics.